Stores Ltd and another Lidl Great Britain Ltd and another.
Yes, Mr. Birss.
My Lords, as you're aware, I appear for the appellants in this matter with Mr. Cuddigan, King's Counsel.
Yes.
Then friend Mr. Brandworth, King's Counsel, Mr. Cronin, and Mr. Sherlock are here for the respondents on the main appeal. So far as the various issues and the order in which we should deal with them is concerned, there's been some discussion between the parties, but we're very much in your Lordship's hands, of course.
Well, if you agree to running order and a timetable, well, that makes our life easier.
Yes. My proposal was to open the appeal on the primary issues of trademark infringement and passing off. Mr. Cuddigan to follow me on the issues of copyright and the injunction. So in other words, we run our appeal straight through. Then my proposal would be that that appeal is dealt with. In other words, your Lordships then hear any submissions to the contrary and a reply before my learned friends run their cross appeal on bad faith. I think as the court, my Lord Justice Lewison's already pointed out, that has no obvious impact on the inter partes dispute, given the concession that was made that the wordless mark makes no difference to the case on infringement. And it does raise completely, largely unrelated issues to those in the main appeal. So my timing proposal would be that I run through till roughly mid-afternoon. My learned friend Mr. Cuddigan follows and finishes sometime tomorrow morning, say at 11:30. Then we try it. Then Mr. Brandworth goes. We have the rest of the time until lunchtime on the third day to deal with the trademark passing off copyright issues, and then half a day on the bad faith. Obviously, we had originally given a 4-day estimate. I perfectly understand your Lordships cut that down to 3 days. I'm trying to keep my submissions as short.
Well, you'll bear in mind that we've obviously read the judgment and the statement documents, so we know.
We have the great benefit.
What the issues are.
The great benefit of a court that is familiar with the law in this area, so that also cuts down to some extent some of the introductory submissions. I will endeavour to be as short and precise as I can, and to only show you passages in the authorities that I think are really necessary, similarly passages in the evidence. But I can't avoid having to take you through some of it, which, with the usual business of taking bundles out, getting them open, looking at the passages does take time.
All right. One other thing to mention in terms of timing, and that is this morning we'll have to rise at 5 to 1.
My Lords have read the judgment and will no doubt already have been aware of the identity of the parties to this dispute.
Yes.
The background facts are common ground set out in the judgment, the pleadings and the evidence. Just to summarise, put it into some kind of context, Tesco are of course the leading retail grocery supermarket in the United Kingdom. They have multi-millions of visits from customers every year. Still more use the website for online purchases. Their brands, Tesco and Clubcard, are two of the best known in the country. Clubcard is, as the judge found, the gold standard for customer loyalty schemes, not only in the UK but globally. And some 16 million shoppers, as at the date of the pleadings, had one. Tesco's share of the market in retail grocery supermarket shopping is over 25%. So it's a matter of logic, it seems likely the majority of people in the country shop there from time to time. Lidl are also a major retailer in supermarket groceries. They're a relative newcomer, a German supermarket originally known for discounted products. They entered the UK market in 1994. I think a few years after another German discount supermarket, which we'll have to look at a bit in the evidence, called Aldi, which had come on the market with a similar proposition. Both Lidl and Aldi have gained shares of the UK grocery retail market. I think Aldi's slightly bigger, but Lidl takes a solid 6% or so of the market. The complaint that led to the trial concerns Tesco's club card pricing campaign, which began in September of 2020. In summary, the club card, which was a membership scheme for people who shopped in Tesco, had always provided benefits for members in various ways, and that no doubt accounted for its success with consumers. But in 2020, Tesco decided they'd establish a new and simplified discounting policy, rather than a mishmash of special offers and reward schemes. They'd establish a single regime of discounted prices on certain goods which would be available only to club card holders. And to indicate the existence of these discounts on the particular goods to which they applied, they would need a new sign which made the message as clear as possible. Here are special club card prices which you'll be able to take advantage of if you have a club card. And they turned to outside agencies, as you've seen in the judgment, to help them design and subsequently to consumer test the signage. And what they ended up with, as you'll have seen, was the use of two colours against which to present the message that they were conveying to customers. A blue background colour, which is the Pantone, well established already as part of the Tesco livery. As you'll have seen in the judgment, Tesco use two primary colours in their general livery, blue and red. The blue, as we'll see in many of the pictures which we'll look at, is present all over the Tesco shops, on the fascia, obviously on the logo, on trolleys, tills, etc., and all over the website. In the signage, the blue takes the form of a square, sometimes a rectangle, and superimposed on this blue background is a yellow roundel. The yellow roundel is used to highlight the text which conveys the message. Just in passing, because we'll come back to this, if your lordships have got the judgment, which is, I don't know if you're taking it from the core bundle, so you've got it separately. In the core bundles, it's at tab 28 of core bundle B. The judge makes a number of points, some of which may seem self-evident, about the use of yellow in signage at paragraph 186. From the middle of that paragraph, yellow has been recognised as having the best impact for the point of sale material. Also accept other supermarkets use yellow, including yellow circles, to indicate value propositions to customers. The yellow value roundel was already a part of Tesco's messaging arsenal, albeit in the context of packaging. And then she points out it was come up with by the specialist design agencies. and indeed the evidence was that Tesco's had received advice, encouraging advice on the utility of yellow in particular to convey messages of value to customers from their design consultants. I won't take you to it, but I'll give you the reference. It's in Supplemental Bundle B, tab 25 at page 365. Yellow, reasonably commonplace so far as the judge held, known to have strong impact, recognised by the marketing people as a value colour, and used by supermarkets generally, and Tesco in particular. Turning to some of the ways the signage is used, I think the best place to turn to for examples of this, because there's only a couple of images present in the judgment, is the statement of Miss Farrant, who was Lidl's witness at the trial, and that's in Supplemental A, tab 3, and one sees there a range of examples of the logo. It's shown in a pure form simply with club card prices on page 49 at 106. And then you'll see some actual physical instances of it being used for particular price messages over the page at page 50 in paragraph 109. And just again in passing, what you see above that is a single frame from an advert which was I think shown on television, that is, this link is to a YouTube version of it, in which a shopper goes around a supermarket transforming prices with a zapper, presumably using some virtual Bluetooth mechanism for transforming these prices into club card price, thus conveying the message that she is getting a bargain as a club card holder. But those are, as it were, this is a virtual representation rather than an actual shop. Plainly, you can't go around a shop with your zapper achieving this kind of thing. Page 53, you'll see some more examples, slightly different usage from the website, where you've got club card price and then the actual price written down next to it in a yellow rectangle. And then 54, you've got a series of shots of a large Tesco Extra store with large club card price signs on the outside, and then you get a shot of some aisles with the club card price advertising, as it were, either hanging from the ceiling or projecting from just above the shelving units. 55, you can see how it appears on the shelf edges. So there are goods here which are £3.50 if you're a non-club card member. That is the top shelf, and £3 if you are a club card member. I think it's part of a meal deal by the looks of it. And then you see some wine on the bottom right, where it's reduced from £11 and £12 to £10 if you're a club card member. And then you have other examples on 56 of sort of banner usage hanging down from shelving and some more shelf edge signs with the particular reductions top left and so forth. Over the page at 57, I only show you this because it may be relevant to something we'll talk about later. The picture on the right shows also some red signage, which is the Aldi price match campaign, which Tesco was also running from before the Lidl campaign, showing the words Aldi price match with a tick in a red sign. So far as the technicalities of the mark for sign comparison are concerned, the judge obviously had to identify what the sign was in this case, and there was a dispute between the parties at trial. If one looks at the judgment at behind tab 28, you'll see at 562, paragraph 7 of the judgment, what Lidl said the sign was, and they had essentially excised any text from the signage as used by Tesco. But Tesco's argument was that was profoundly artificial, particularly bearing in mind the importance of the messages that were conveyed by the sign to the overall impact on the consumer. So the judge...
As I understand it, Tesco never used the sign as shown on the left-hand side of that comparison.
Yes, and the judge recognised that. The only reason I'm showing you is that it can be confusing when one looks at paragraph 7, because one thinks, oh, well, that's the sign. But in fact, the judge found that wasn't the sign. And the sign is the full thing. So she gives an example at the top of 563 with the words written on it. But as we've seen, there are multiple different messages, but they all have in common the club card trademark, the club card message, and the pricing message one way or the other, either in the general term club card prices, or if you're looking at the goods, the specific price of the goods that are being reduced. So that was the judge's finding, that was the sign. So in fact she was saying there are multiple signs here because they vary. And the truth is, of course, everyone who goes into Tesco and shops is going to see multiple examples of the different variants of the CCP signage. Many of them, as we've seen, have the normal price next to the club card price, so that you are told precisely what the benefits are of using the club card for this particular purchase. The message, so far as club card pricing is concerned, is therefore conveyed not only by context, but in terms of the sign itself. I should say I've given examples so far of the signage as it's predominantly used and experienced by consumers in Tesco stores and on the website. But there were also, of course, various TV advertisements and press advertisements put out in 2020 and 2021, which would have been seen obviously in a different context from the store or the website, promoting the club card prices scheme. And we'll look at a couple of these in a bit more detail. One of them, of course, was the one I've already shown you from page 50 of Ms Farrant's statement.
I think she also includes some images of newspapers with Tesco's
Yes.
advertisement on them.
And we'll look at those when we come to the evidence that the judge considered that was relevant to those particular usages. I'll come to what we say is a bit of a difference so far as the impact of those on consumers is concerned. The signage was not only designed in conjunction with independent designers, various options and variants and different signage were independently tested by marketing experts on Tesco's behalf with members of the public. And when the signage was tested, the one that was adopted, which is subject to complaint in these proceedings, was the one that performed best against the metrics which Tesco wanted to achieve. And what they wanted in particular was signage that would be noticed by customers, would call out a different message about loyalty and the benefits of loyalty to the famous club card. And this turned out to be the best option from the point of view of, I'm using their phrases, standing out, clarity and rewarding loyalty, which we would submit are obviously legitimate and important characteristics given the purpose of the sign. And this is set out in the judgment at 127 Little Roman 6. And this is the research being carried out by the organisation called the Source, that's 596. So they were, and we'll look at this in a little bit more detail later as well, they were asked to look at 4 options with consumers, and option 4, which ended up being the one which is the sign subject of dispute, was the one, as the judge said, that pulled ahead in relation to measures such as standout, appeal, clarity and rewarding loyalty. And I mention that now because it's convenient to deal with a slight oddity of supermarket marketing campaigns that became apparent in the course of the evidence in this case and is picked up by the judge. The importance of signage in a campaign which stands out and conveys a clear message is particularly critical to supermarkets, where, as here, it is common ground that the misattribution of marketing campaigns by the public to the wrong trader is a major problem. I mean, put bluntly, the problem is that someone sees an advertisement for a particular retailer, perhaps on television or passing a poster that's on the street, has a quick look at it and remembers it as an advert for someone else. And Ms Farrant's evidence at paragraph 56 of her statement refers to it as a curse. Sorry, it's page 31, tab 3 of sup bundle A. And you'll see that in paragraph 56. It's been her curse. I think she was the marketing director since 2015. Particular curse that Lidl suffered from was being thought to be, that adverts were thought to be Aldi adverts. And again, we'll come back to that particular type of confusion.
May tend to suggest that UK consumers are not particularly perspicacious or well informed.
Yes. I think it also indicates that where one's concerned in particular with a TV advertisement or something you might briefly see on the street, it's perhaps not surprising that people's level of interest, if I can put it that way, is relatively limited, and they just come away with the wrong message. One of the pieces of evidence here was that there was one advert that that Lidl put out, which was widely mistaken for Morrison's, so that actually more people thought it was a Morrison's ad than thought it was a Lidl ad. I won't take you to it, but it's supplemental C at 893 to 4. What we would say is it illustrates how you can have in this business amongst the public a kind of low-level confusion and annoyance going on for years without it being an actionable deception having a great impact on the business, and how the industry has essentially bumped along with it. Perhaps it's not surprising because everybody wants to use primary colours. Everyone wants to use simple and effective messages, but they can't help the fact that customers often don't behave particularly carefully when they're looking at advertisements in particular. The phenomenon of misattribution, which was the term used at trial, is well, my point is it's the best name to call it. We would say it's not really origin confusion because it doesn't actually lead to a purchase of a product and a false belief that it's from someone else. It's actually a simple mistake about who the advertisement has come from. And it won't actually drive trade towards the party whose advert it actually was, so it doesn't have any benefit for the party who is inadvertently creating the mistake. And that, of course, is why one reason why the supermarkets like Lidl themselves and also Tesco are so keen to avoid misattribution. They don't want to lose the value, even to that extent, of their campaigns and benefit their competitors. But it played a part in the judge's decision, and we'll come back to how it did that, but we would submit it needs to be looked at as a slightly different situation from the real complaint in this dispute, which was really a true allegation of deception. So when Tesco tested their advertisements at the outset of the campaign, they were looking for the minimum kind of misattribution of this sort. They wanted Signage to really cut through with customers so that they could tell it was all about Clubcard, it was all about Tesco, and therefore it would maximise the value to them of the campaign. And the independent reviews that were undertaken did show that it had achieved a very high brand linkage. Indeed, Hall & Partners, who did the reviews that we'll look at, having tested 14 other Tesco campaigns since 2019, said it was the highest brand linkage that they had ever seen. I should say that's confirmed in the evidence of Mr Marks at paragraph 12. It hasn't found its way into these bundles, but it's consistent with all the findings of the judge. And the judge did record that amongst those to whom the various marketing campaigns were shown in these Hall & Partners surveys, only 3% misattributed the advertising to someone else, which was considered extremely good. The other point I want to make before coming to the meat of the appeal is that it's common ground before your lordships, as found by the judge, though Lidl contended differently at trial, that this is not a case where Tesco had any intention of conveying any kind of message, subconsciously or not, that there was a link here with another trader. This is not a United Biscuits and Asda, Penguin and Puffin type case, or a Specsavers case, where they were trying to sail as close to the wind legally as possible in order to gain the benefits of association. And the judge was extremely clear about that in her judgment at paragraphs 151 through to 155, accepting the particular evidence of Miss McKettrick, who was, I've forgotten her job title, she was the counterpart to Miss Farrant, Group Brand Director, who, as the judge says at 151, rejected any suggestion that aim had been to transfer the value perception enjoyed by Lidl to Tesco, said that Tesco never sought to establish any association, quite certain hadn't sought to free ride, and says it would have been part of my role at Tesco to ensure there was no real danger of it. And then there's an important quote in this respect at the end of 151 about the importance of the club card brand to Tesco. It was unique, it was one of the crown jewels of their goodwill, principal objective to maximise developed brand value. And then she says it would have been anathema to me and to Tesco to allow the club card brand to be muddied or polluted by association with any of Tesco's competitors. Indeed, contrary to the whole objective of the master brand project, which was to present customers with clear and consistent Tesco brand messaging, and the judge goes on. But that, we submit, is very clear. She was regarded by the judge as an impressive witness, and their evidence was accepted in its totality. And it's consistent, of course, with Tesco having taken many steps to market test their signage, and both in the course of selecting it and having selected it to ensure it was as clear and directed as possible. And quite plainly, they wouldn't have gone ahead and launched the campaign if they'd had any belief of a risk of significant confusion or significant association with a rival, not least because this would have been a complete distraction from the key message that they were keen to convey, which was that of loyalty and value obtainable with a club card. Turning now to the nature of Lidl's claim, both in respect of infringement of trademark and passing off. And the first and most obvious point to make is that this was not a case where origin confusion, the traditional kind, was the allegation being made. There was no serious allegation that the average consumer would think that Tesco were Lidl or were selling Lidl products. And that's no doubt why no claim was made in this case for infringement under Section 10, subsection 2 of the 1994 Act. And that's a point that the judge makes at 146 in particular. Making the point in the middle of that paragraph, which is of some importance, that the scope for misattribution when viewing the CCCP signs in a Tesco store or on a website is obviously at or close to nil, because the average consumer will know that she's in that store or on that website.
I beg your pardon, I think I'm in the wrong paragraph.
I'm sorry,
Could you give me-
146, which is on page 603.
Right.
I was just reading from the middle of that paragraph. The argument was more complex. It was that the average consumer would believe that the use of the yellow roundel against the blue to display the price was intended to show that Tesco had price matched their products, or rather the product that was the subject of the sign, against an equivalent Lidl product. Thus, the argument went, a consumer would be led to believe that they didn't need to go shopping at Lidl for that product to save money, or even need to check the prices that were available at Lidl, and therefore there was effectively an actionable deception. We give references to the way that argument was put at various points at paragraphs 8 to 10 of our skeleton argument.
That's the way that the claim is pleaded in paragraph 22b of the re-amended particulars. That's our tab 1, page 18, and again under passing off on in paragraph 28.
Oh, it is. And the judge's ultimate finding, of course, was that this had been established in the case of the average consumer so far as trademark infringement was concerned, and in the case of a substantial number of ordinary consumers for the purposes of passing off. And we give those references to various points at which the judge referred to this in paragraph 13 of our skeleton on this appeal. These findings, of course, lay at the heart of the finding of infringement on the basis of unfair advantage and detriment due to a change of economic behaviour on the part of consumers caused by the making of a link, which was the allegation under section 10.3 based on the pleaded case that my lord has pointed out, and also the deception which is at the heart of the claim of passing off. And the reason I've gone through that somewhat tortuously is that although this was a 10.3 case, and therefore sometimes one thinks, oh well, that's not about confusion and deception. What was alleged and needed to be established here was a form of confusion or deception, not the normal form, but a form of confusion. Because of course, no formal price matching exercise with Lidl was ever done or intended to be done by Tesco's. I should say, in relation to price matching, there was some evidence about this as an industry practice, and when the judge talks about price matching, I think the witnesses are talking about price matching. They're not just talking about well, you're trying to make sure that your products are generally competitive, which is perhaps one sense in one might use the word. You've seen that these goods are 10p cheaper in Lidl and you've brought your prices down. What they're talking about is something that acts as a kind of guarantee to the consumer. So the evidence of Miss Farrant about this was that when one has these price matching campaigns, one's immediately in the hands of the advertising standards people, because they will monitor what you're doing, and if in fact it turns out that you're not properly monitoring the price of the competitor that you're seeking to price match, they won't allow you to advertise the fact that you are price matching. So it's a bit of a pain, is the thrust of her evidence, to engage in, because you've got to be on it the whole time. You've got to be monitoring exactly what your competitor is doing with their price in order to say that you've matched it. So it's essentially a kind of formal guarantee to your consumer that you are specifically monitoring the Lidl price, and in this case, and you can be sure that the Tesco price is less. And that, of course, is what Tesco were doing with Aldi, as indicated by those red signs that said Aldi price match. And they'd made a big campaign of the Aldi price match, including on their website. And no doubt you could find out exactly what the terms of that were, how they went about checking the prices, if you followed through the links on the website. But this was the fundamental allegation, that customers would take that practice, or that industry practice, as having been done here by reason of the blue and yellow background to the signs. And if that was right, then despite all Tesco's best intentions as accepted by the judge, it must follow that they got it wrong and misjudged their own customers, causing them to think something that Tesco plainly did not want them to think. And when we look at the evidence and what the judge said about it, I'll try and call this price matching confusion to distinguish it from misattribution, which is the kind of thing that one sees with the advertisements, which the judge occasionally called origin confusion. And I'm not going to spend a lot of time on whether that was in fact the right usage, but she does use those two terms interchangeably on occasion. But we submit those. The important thing to have in mind is that these are quite different phenomena. Misattribution is a simple low-level mistake when you've glanced at something, thought it's something that it isn't. The price matching confusion actually requires a thought process of some kind, which is, we would submit, not sophisticated, but certainly quite specific, involving the concept of a price matching campaign by one supermarket.
Can I ask you a question about that? How
Yes.
far do you go with that submission? Is it your submission that these processes cannot be subliminal?
I can imagine that one could, in some cases, have evidence which established that that kind of thing could go on subliminally. But it's quite difficult to see how it could happen, because first of all, you've got to see an association with Lidl, and then you've got to think, what's going on here? This is something quite specific, not just, oh, that's a bit close to Lidl, which some of the evidence shows the odd person thought. But Tesco are actually doing something here specifically about the prices, and they are telling me a specific message. I'm obviously not a psychologist. I'm not sure whether that could happen subliminally, but we would submit it's difficult to see how it would ordinarily happen subliminally. Just before going to the judgment and the evidence, I want to make three submissions on the law, which I think are uncontentious but important when we look at our objections to the way the judge approached the case. And this is probably a convenient point at which to do that. The first is that, and I've alluded to this point I think already, that trademark infringement and passing off are all highly context dependent. The usual reference for that proposition is the Specsavers decision, which is quoted by the judge in her account of the law, which we don't generally take issue with at all. And this particular passage is in paragraph 73, little 14. The propositions of law run over several pages within a single paragraph, so it's slightly confusing, but it's on page 579. And that's the well-known quote from Specsavers at paragraph 87 of Specsavers, quoted there at subparagraph 14. Must consider the matter from the perspective of the average consumer, must take into account all the circumstances of that use that are likely to operate on that average consumer's mind in considering the sign and the impression it is likely to make on him. The sign is not to be considered stripped of its context. And obviously, a point I've made earlier, here the signs are used in different contexts. The primary context is in store and on the website, but it has also used the sign in advertising on television, in the press, and in out-of-home posters, etc. The judge ultimately made no distinction in terms of her finding of infringement between different forms of use. All forms of use were therefore apparently considered to be infringement. And I'm going to invite you to consider infringement, therefore, by reference to what must be the paradigm and typical condition in which the customer sees the use of the mark, namely in store, indicating the goods being promoted by club card prices under the campaign, or in the website. Again, where it's obvious that you are present in a Tesco property. And that's just to make the point that I think I've already made. The judge accepted at 146 that in that context there was no risk of misattribution / origin type confusion. And therefore that kind of confusion should not really have played a part in the determination of the actual type of deception under consideration. The second and more important point is the notion of the average consumer. Again, the judge cites all the, I think almost all the relevant authorities in recent times on this subject.
Can I ask you about that question?
Yes.
Because of course, the concept of the average consumer, it was developed in the context of trademark infringement by the Court of Justice of the European Union.
It was.
What do you say the relevance of that concept is in the context of a claim for passing off under English common law?
I'm going to come to that, if I might, when I'm going to deal with the average consumer, and then I was going to, in passing, address precisely that question by reference, in fact, to, I think, my Lord's own decision in Enterprise and Europe Car, which I think...
Of some antiquity now, yes. I think you'll find more recent statements from me on that subject, but never mind.
Well, yes, one has in the end to be economical with the authorities. But I will submit that what you've said there represents the law. It is not the same test, but it has sufficient similarities for my purposes. And I'll explain why. But I think it would be easier, if I may, if I can just deal with the position of the average consumer in trademarks before explaining why we say passing off can be dealt with in a very similar way. Yes, it goes back not only to the earliest days of trademark jurisprudence under the Court of Justice, but before that it was already part of European jurisprudence in trade descriptions law, and that's where the language that was adopted ultimately came from in the Lloyd Shoe Fabric and Mayer decision. And if I can adopt a quote from, I think, my Lord Justice Arnold, it was invented to provide the court with a normative benchmark, and in particular a normative benchmark with regard to the standard of perspicacity to be assumed on the part of the public for the purpose of trademark infringement. I think you'll find that quote in, again, the legal summary of the judge, this time in subparagraph 7(3) of the judgment at 578. Yeah, the quote in the middle of that paragraph from Jack Wills, average consumer provides a normative benchmark with regard to the standard perspicacity to be applied, doesn't require the court to assume that all the persons of whom the average consumer is representative perceive either the trademark or the allegedly infringing sign in the same way, and it doesn't restrict consideration to the reaction of a single hypothetical person. And if we are while we're on this part of the judgment, if one goes back to 577, this is a summary of what was said by Lord Justice Kitchen in the second Interflora case that came to the Court of Appeal, that it's created to strike the right balance between the various competing interests, including, on the one hand, the need to protect consumers, and on the other hand, the promotion of free trade in an openly competitive market, and also to provide a standard defined in EU law which national courts may then apply. She will normally be representative of people with a spectrum of attributes. So this now comes from Lord Justice Arnold in Enterprise and Europcar, such as gender, age, ethnicity and social group. So the average consumer covers, of course, a range of all kinds of different types of person, different backgrounds, levels of education, etc. But the point of the average consumer is to impose a reasonable level of information, observation skills and circumspection.
Yes, so you're excluding the ends of the distribution.
Yes, sometimes the
Either
tails.
way.
Yes.
You exclude those who are ill-informed and unobservant, and you also exclude those who are highly specialised and picky.
Yes. The only thing I'd add to what you said in Enterprise and Europcar there, which is quoted at 8, is that perspective of those who are ill-informed or unobservant or not circumspect, because that's obviously the other of the three attributes. That we will submit is one. I mean, Your Lordship makes the point that there are outliers in the population.
Is circumspect different from careful?
Cautious, careful, it conveys that kind of just general care. But we would submit when we come to passing off and the average consumer and the substantial number of ordinary consumers, which is the test for passing off, we are in the same ballpark, but I'll come back to that. There are 2 points we would say philosophically about this. One is this question of the bell curve and the outliers. There are people who don't fit the character of the average consumer, just because of the nature of the way they approach the world. They jump to unreasonable conclusions, or they're not circumspect in the conclusions that they reach. I was reading the other day, it's not in the evidence, that 16% of Britons apparently believe it's probable the moon landing was faked. We're talking about a small number of people, but it may be a considerable percentage of the population who don't exercise particular circumspection in the conclusions that they reach. And it's adopting the Lord Justice Kitchen approach. It's not reasonable to expect traders in a free market to avoid confusion amongst everyone, because there will always be people who get confused whatever you do. And it's not easy necessarily to identify, just from even speaking to them, who's an outlier or who's unusual. Some people just are unusually gullible, some people are absurdly cautious. But the second aspect is not necessarily one of character, but one of circumstance. Because an entirely typical and ordinarily cautious person may, on an occasion, approach a sign in a way that falls below ordinary standards of circumspection. In a store situation, they might momentarily be completely distracted and not really look at a sign at all. Just grab something off the shelf without actually observing what the sign says, just by, for example, the colour that's used. Again, that's perfectly normal. It will cause, occasionally, coming back from the shop with the wrong thing and being told by your partner to go and get the right one. But again, the court's not concerned with such instances, which are an inevitable part of life. But if the court was to intervene every time such a case happened, it would be an unacceptable interference with freedom of trade. So there are those two different aspects, type of person, type of circumstance, that this whole question of the average consumer and the standards of perspicacity raises. And the role of the judge, we submit, is to put themselves as best they can in the position of an entirely notional average person, applying reasonable circumspection and observation to a sign in the context that's actually complained of, and in circumstances where they're able to apply a reasonable degree, and I emphasise reasonable, of circumspection and observation appropriate to the transaction. Doesn't mean that they have to think particularly deeply about the issue, but also they don't leap to unreasonable conclusions. The person may come from any background, have a variety of life histories, but cannot ever sidestep the actual requirements that the average consumer imposes.
Now, in phrasing the question in that way, I assume that you're not intending to suggest that there is any single meaning rule here. On the contrary, I would assume you would accept that different consumers in the class with which we are concerned will perceive the signs in different ways, and the law has to take account of that.
Yes, the court does have to take that into account. It's perhaps more of a problem with particularly complex signs, perhaps less of a problem with perfectly simple signs, but of course that is the right approach. Can I turn just to that question of passing off and how it relates to trademark infringement? And I know there have been a variety of statements about this going back many years, but I was going to suggest that the position adopted in Enterprise and Europcar is a fair statement, and it's in the authorities 11 at That's paragraph 158.
Sorry, Mr. Purvis, I missed the paragraph number.
Sorry, my fault. 158.
158.
So this is in relation to passing off, addressing head-on this interrelationship between the test for passing off and the test for trademark infringement. And here, Your Lordship adopts the statement of Lord Cranworth, ordinary purchasers purchasing with ordinary caution, are they likely to be misled? Then the famous only a moron in a hurry of Mrs Justice Foster in Morning Star, and then Lord Justice Roma in Paynton and Snelling. That's a customer who knows the distinguishing characteristics of the plaintiff's goods, those that distinguish his goods from the other goods. The customer must be one who, knowing what is fairly common to the trade, knows of the plaintiff's good by reason of these distinguishing characteristics. I'll come back to that phrase, but it is something which, even for the purposes of passing off, you assume that the customer is aware of.
All right, but what do you say about the fact that in 159 I explicitly reject the submission that the standard applicable in passing off is the average consumer?
Yes, well, what you say is you're doubtful it represents a materially different standard to that applied by the English law passing off, although there is a conceptual difference. And then you say, in any event, I don't accept the submission that the law has effectively changed, that you have to approach it from the perspective of the average consumer as defined by the Court of Justice. You point out in the middle of the paragraph that it's part of the English law of unfair competition, and make the point towards the end of that paragraph that it shouldn't be applied in a manner creating an unjustified barrier to trade, that you don't consider it requires claims passing off to be assessed from the perspective of the average consumer. So we don't have to completely elide the law of passing off and trademark infringement. However, there clearly are policy considerations which are the same. We've already looked at what Lord Justice Kitchen said in the context of trademark infringement, about the whole point of the average consumer test being to maintain a balance between freedom of trade and protection of goodwill. And exactly the same policy we would submit underlies passing off, because it is a species of unfair competition. The references that one sees in all the authorities to ordinary purchasers purchasing with ordinary caution, which Your Lordship has adopted, are very similar to the characteristics of the average consumer. And we would submit there's little obvious policy reason for the courts to pull hard at trying to separate out the two tests. Clearly one is a matter of substantial numbers, I accept, but it is substantial numbers of ordinarily cautious consumers. So one's in the same ballpark.
Well, I understand that. Do we need to get into this question anyway? Because the judge recorded it was common ground at trial that the passing off claim stood or fell with the trademark infringement claim, and both parties are adopting the same position, their skeleton arguments on this appeal.
I certainly didn't perceive anything in Learned Frenska which went against that. The parties have tended to view this particular allegation, which, as I say, is one of deception of consumers, as pretty much the same, whether viewed from the perspective of passing off, or viewed from the perspective of section 10.3. I perhaps spent too long on it in the light of the comment your lordship made earlier, that that's, in my submission, a correct statement of the law, and we don't really need to look beyond that for the purpose of this case. So I've kind of finished this particular subject. The point is, it's perfectly consistent with non-infringement, and it's perfectly consistent with non-passing off, that some people might sometimes be confused. And as the courts are constantly saying, coming to court with a person who's confused doesn't win you the case, because mistakes get made, people can occasionally be confused, and that's not necessarily actionable. The third point, which again crosses over between passing off and section 10.3, is this question of the impact of confusion. There's obviously a spectrum between, and this is clear in so many of the authorities on 10.3, between being reminded of a mark in some way, seeing a link, and actually being prepared to rely so much on that link that one changes one's economic behaviour. And the courts have made clear in the Intel case onwards that it is not enough for the purpose of 10.3 simply to see a link. You have to get as far as changing your economic behaviour, and you have to show the average consumer will do that. In the context of this case, it would require an actual belief upon which you're prepared to act as a consumer, that this is actually a price matching campaign, because otherwise you have no basis for changing your economic behaviour by not going to check the price at Lidl, by maybe not shopping at Lidl at all, or whatever the allegation is. And we would submit actually the same goes for passing off in this kind of case. You have to get to a stage of damage, and as Lord Justice Jacobs said in Reed, mere wondering is not enough. I mean, that's very similar to the distinction between mere bringing to mind and actual change of economic behaviour. Being reminded of the Lidl sign, or even being annoyed that Tesco were using yellow and blue, which is the case with some of the evidence we'll look at, is never going to be enough for either cause of action. What I was going to turn to now is our central submission of what the judge should have done, given the findings and the largely uncontested facts of the case before her, and then to turn to what she actually did, why we say that that was not an appropriate way to deal with the evidence in this case. And for that purpose, I will show you a series of cases, most of which are summarised in the first Specsavers decision by Lord Justice Lewison, which proves
it must mean Interflora. I don't think I had.
I'm sorry, Interflora. I'm looking at the word Specsavers with my terrible glasses, and should have gone there. I said Specsavers. I'm sorry. It was in Interflora by Lord Justice Lewison, which proves a very useful summary of most of the propositions that I want to make on the value and utility of evidence in a case like this, and the kind of evidence that may or may not be useful. But as you've seen from our skeleton, we say that in a straightforward and simple case of retail transactions like this, where the facts were largely uncontested so far as the objective circumstance of use of the sign is concerned, the judge's task was relatively simple. That is to say, standing back, putting herself in the shoes of the ordinary, reasonably observant, well-informed person. Would she think that, or would that person think that this was a price-matching promise against Lidl by Tesco? We would submit the answer to that is plainly not. What they would see is a club card pricing sign advertising a new deal in which Tesco are offering special discounted prices to those with club cards. They'd see the use of two primary colours, something hardly unexpected in this field, one of which is Tesco's own livery blue colour, the colour actually of club cards themselves, and they'd see a yellow roundel, something they wouldn't be surprised to see, again because it's commonly used in retail to indicate value, and I've shown you, I think, already the judgment in this at 186. And it's for that reason I showed you the reference in Lord Justice Arnold's Europe car case. If the consumer is deemed to know what's fairly commonly used in the trade, then they will not be surprised to see yellow. Now, if they're also familiar with the Lidl logo, it is possible the kind of customers who like to think about these things might be reminded of it by the yellow roundel inside a blue box. But they would obviously see two pretty important things comparing mark for sign and understand them immediately. First, it doesn't contain the word Lidl at all. And second, it doesn't have the characteristic red rim around the yellow roundel. So it's not the Lidl logo, and couldn't be confused with the Lidl logo. So why would a reasonably circumspect person in those circumstances think from that information alone they were being told that these goods had been price matched as part of a campaign of price matching against Lidl? First of all, it would require some understanding of the practice of price matching as a commercial activity of retailers. And as I've said, it is something that's done from time to time. There was evidence about it, but there was no suggestion in the evidence at all that it was ever done other than entirely explicitly and clearly by reference to the actual name of the store being price matched, or that it was ever done save by actually stating that there was a price match going on. I mean, so far as this is concerned, the only actual evidence of a price matching campaign was the Tesco's own Aldi price matching campaign, where both of those were clearly done, as your lordships have seen in that red round. It gives the name of the store being price matched, and it says there's a price match. And we would submit it would be very, very odd for a retailer to try and convey this message without doing either of those things. Second, it would require you to think that something pretty sophisticated here is going on. In other words, the club card price campaign, which is very clear and has the cut through that the marketing people found, has got two distinct meanings. First, to tell you that you get a discount on Tesco's own prices by having a club card, which is what's stated explicitly. Second, to tell you the same discount was also a guarantee of a cheaper price than Lidl, though presumably not Aldi. And this is not stated at all, but is said to be implied by the yellow roundel on the Tesco blue. Quite a confusing and odd thing to have done, and therefore a confusing and odd conclusion to reach, we would submit. And third, it would require you effectively to have discounted obvious and alternative reasons for the use of the yellow roundel against Tesco's blue, bearing in mind your deemed knowledge of the kind of things you ordinarily see in trade, like, as the judge has found, yellow roundels indicating value. So you have an obvious reason, if you're going through any kind of thought process, that this is a yellow roundel. It stands out, it shows value, and to put it the way that's sometimes put in these cases, it's not the kind of sign which you'd never expect to come across outside Lidl's stores or marketing. And we say the whole idea that the average consumer, with the degree of perspicacity which the courts have given them, would conclude, so as to change their economic behaviour, that the sign was advertising a price match against Lidl was a contradiction in terms, because any such thought process, by definition, lacks circumspection. It is speculative and irrational. Not to say that you might not manage to find someone who reached that conclusion, just like you can find people who think the moon landing was faked, but it doesn't mean that well-informed people of normal circumspection would reach that conclusion. And we say, essentially, the judge, having seen the evidence, should have reviewed the matter in those terms and simply dealt with it as a matter of common sense. Of course, she'd admitted a lot of evidence, and a lot of evidence
can I
had
be
been
clear? How far are you taking this submission? I totally understand that your case is it's a matter of assessment by the judge applying the correct standard. That I understand. But do you go so far as to say the evidence that she reviewed in the judgment was either inadmissible or, even if strictly admissible, irrelevant?
Some of it was probably irrelevant. Our submission is this, that having admitted the evidence and heard submissions about it, she was perfectly entitled to review the evidence. It's a perfectly proper thing to do, but she should have been reviewing it to see whether it was essentially inconsistent with the view that she could come to on effectively an ordinary retail transaction, putting herself in the position of the average consumer. So was there anything here that caused her to think, actually, maybe I'm wrong? There are millions of people who seem to have been confused.
On that approach, what in your submission should the judge have done if she had concluded that her own view was that the signs were carrying the message that Lidl alleged?
Sorry, so her own view was independently reached.
Correct.
Was that the average consumer would be confused.
Correct. I'm asking you to assume that. Obviously, you argue strenuously to the contrary.
No.
But the reason for asking the question is obviously to test what is the role of evidence in these circumstances.
Yes.
And your argument, which is very clear, is you say the judge should have applied her own assessment. She should have concluded that there was no case, and she should have then checked the evidence to see if that contradicted her own assessment.
Yes.
But I want to find out from you what you say she should have done if she'd formed the opposite conclusion applying her own views. What would be the role of the evidence in those circumstances?
I hadn't looked at the case quite that way, but if that was the approach, one would be able to interrogate or try to interrogate the evidence to see whether it dented one's opinion.
Well, I mean, in a way, it's a two-pronged question, isn't it? Because the evidence, assuming the judge came to the view that my lord has posited
Yes.
that the signs did convey the alleged message, either the evidence would have confirmed that,
Yes.
in which case it's doing no more than backing up her own impression, or it would have contradicted that. And that's I think, what my lord
Yes.
is driving at. What's the judge to do
Well,
if she thinks it conveys the alleged message, but there
Yes.
is no independent evidence to that effect, and indeed the independent evidence is to the contrary?
if I may, I'm going to say it would depend on the evidential value of what she had in front of her. So, if she would have to look at each piece of evidence, first of all to see whether it had evidential value so far as the response of the average consumer is concerned. And secondly, whether that evidential value was so strong or such that she could change her mind because it was so powerful, indicating
Yeah.
effectively lack of confusion. The submissions I'm going to make on the evidence are that the very nature of this kind of evidence meant that it would be highly unlikely to have been enough to dent the judge's conclusion if she had reached it. She might have thought there's surprisingly little here, considering my view that the average consumer is out there being confused. It's difficult to put oneself necessarily in the shoes of someone who's come to that opinion.
Just to pick you up on one very small point.
Yes.
My lord asked you, did you say this evidence was inadmissible? And you
Yes.
said no, but some of it was irrelevant. My understanding is that if evidence is irrelevant, it is inadmissible.
Yes. Well, we didn't submit. Your lordship's quite right. I mean, and right to pull me up. We didn't submit at trial. It was inadmissible. The judge heard it. I'm pragmatically going to say she could therefore take it into account for what it was worth. And I'm going to say it wasn't worth very much. Whether we've reached the stage of complete irrelevance, perhaps a matter that for discussion that isn't necessary, given what I'm going to say about the evidence. For example, well, I'm probably trespassing on what I'm going to say in more detail later on, but for example, there are surveys. A couple of the things she looked at were surveys. Admissibility, well, they're not surveys done for the purpose of the litigation, so nobody went to court and had to apply to have them admitted. It may be your lordships consider that they're still not particularly admissible in those circumstances, but the parties, as the judge records, went ahead below and argued about them without that submission having been made. Were they relevant in the end? We would say they weren't actually capable of producing any relevant evidence that was going to help the judge find infringement. But it's difficult to address in the abstract. I think when I make my submissions on the evidence, I hope it's clear. Yeah. I understand the thought experiment of what if the judge had thought it was infringement? Could it have changed her mind? And my answer is yes, evidence can, but it's actually quite difficult to imagine a specific case where it's so clear that that would happen. And I suppose one could imagine a case where there were very few customers for a particular product, and the judge thought it wasn't really confusing, but ended up with all the customers go through the witness box, and they all said they were confused and they bought it thinking it was the plaintiff's goods. One might imagine in such a case the judge would be sufficiently impressed to say there was confusion.
Mr. Birss, that sounds like GIF. Isn't that GIF? GIF was the instinctive reaction,
Mr. Justice
no passing
Joanna,
off, but the conclusion was that
I think Neutrogena possibly.
Yeah, I think Neutrogena is
Uh,
probably the better case, because I don't think that Mr Justice
No.
Walton expressed his own view in June.
No, that's right. I mean, Neutrogena, I think I'd forgotten how many witnesses actually went through the box. Quite a lot. It's one of the cases perhaps we'll look at summarised in.
The critical point in GIF was that nobody looked at the label; they just looked at the shape, and that was a question of shopping habits.
That was a question of shopping habits, precisely, and that was quite compelling once the judge had realised what actually happened when you went into a supermarket. Whether Mr Justice Walton had ever been in a supermarket, I don't know.
But is this the point? I suppose this is the point you're making, is it? That you say, well, the task of the court for ordinary consumer goods is to use its own judgment on that. And part of the reason for that is that the evidence is likely to be very noisy. There's bound to be a lot of evidence which is pointing all kinds of directions. And the task of the evidence is then, in cases like that, is to be effectively a corrective factor to say, well, once the judge has formed a view, not a final view, about what is the right answer one way or the other, the evidence might be strong enough to shift it, but it shouldn't. That's the right way of looking at it, rather than being a straw in the wind with evidence pointing in all sorts of directions. Is that? I'm trying to make your case for you.
No, that's exactly where I was coming to.
Right.
The problem one gets is that the ability to weigh the evidence statistically is incredibly difficult.
Well, when in a passing off case have courts in this country ever attempted a statistical approach?
Well, they do look at. There was a time when they looked at surveys. I mean, now less so, but surveys are still admissible. I mean, they are a statistical approach. They have had members of the public go through the box. But what I will be submitting.
Well, let's take Neutrogena as an example.
Yes.
There was no statistically
No.
reliable survey that was relied upon.
No. I haven't got all the details in my head of what was going on there, but I think they had 20 odd or more people go through the witness box, and that was the way of things back in the early 80s or whenever that case was. And also one had surveys, and one had witnesses produced from surveys, and they were evidence heavy in that form. I mean, one of the submissions I'm going to make is when one reads the logic of decisions like Interflora, it is actually a little difficult to see how seeing a few witnesses in the box is of a great deal of assistance. I mean, one of the things that happened in Specsavers was that witnesses of non-confusion were advanced, and the court just dismissed that, said, oh well, just people who weren't confused. But they are, on the face of it, just as useful, surely, as somebody who was confused. Neither are said to be statistically representative of anyone in particular. Neither can, by definition, establish that substantial numbers of people are confused. One is left effectively in the same position.
Yeah,
but anyway,
the logical consequence of your argument, which would be perfectly understandable, is we would do these cases without any evidence.
There is merit in it.
But that
In
was
many
never your
cases.
submission to the judge.
No, it wasn't. And then it's not been the traditional way of looking at these cases. I don't need to go
so
further
the
on
traditional
this.
approach in this jurisdiction, I think
Yeah.
you're accepting,
Yeah.
is the parties put before the court such evidence as they think fit, subject to constraints on survey evidence that are well known.
Yeah.
Survey evidence conducted for the purposes of litigation, I say. And the court assesses it for what it is worth.
Yes, and that's the great question. What is it worth? And that obviously varies from case to case, and it is specific to the cases that come before the courts. And my only purpose on this appeal is to say, in this case, the evidence was profoundly non-probative.
Can I make a plea? It may be difficult for a trademark lawyer, but can you stop talking about confusion? Because this is not a case of confusion at all. This is a case of unfair advantage plus link. Now, nobody's suggesting that any of these consumers were confused.
Well,
As far as I understand it.
Well, this was the purpose of my submission earlier, because the actual allegation which underlies the unfair advantage and detriment case is the price matching confusion. I've called it price matching confusion. The belief that the
Yes.
prices are being matched.
Yes,
That
the question for the judge
Yes.
was not, are people confused? The
No.
question for the judge was, does the sign convey the message that club card prices have been matched with?
Yes. Well, I'm very happy to change my references to confusion to that. I'm sorry. Your Lordship's quite right. It's a shorthand. I did warn about it earlier.
Yeah.
It's my shorthand for the price match. Shall I call it the price matching message?
Yes.
But because it is untrue,
Because
it
I
is
think
actually a
when
form
we
of
come to
confusion.
look, as we probably will, at the way the judge dealt with the question, is the sign similar to the mark? You have to always remind yourself, well, why are you asking the question?
Yes. Yes.
You know, a dog is similar to an elephant if you're going to compare them with a mountain, but it depends why you're asking the question.
Yes, and one of the things that underlies this case is that yes, you've got, as the judge did, the traditional stepwise similarity tick, link tick, detriment tick, but underlying all of it was one real point: would the average consumer see that this indicated an actual price match with Lidl? Because if that's not established, then the case fails. And it doesn't matter that things are similar, or that any kind of calling to mind is taking place. If it is established, then there will be liability. So, yes, it's a slightly odd case from that point of view, which is I tried to convey that message in at the outset, that although it's a 10-3 case, it's almost a species of confusion. But your Lordship's quite right; it isn't actually the form of infringement which is being relied on. Yes, so that's what we say should have happened, and it might be a good time to look, in the light of what we've been discussing, at the types of evidence that come up in these cases and how the courts have approached their utility. Clearly, as Lord Justice Arnold alluded to, there are tribunals going through the exercise of assessing 10-3 or 5-3 or 10-2 or 5-2 every day of the week in the IPO before appointed persons, of course in Europe, in short order, without hearing evidence from the public or evidence of consumer reaction or evidence of internal reactions to a mark or a sign. They carry out what is generally not a particularly difficult thought experiment and produce generally sensible results. But obviously, as my Lord Justice Arnold says, in cases before the UK courts, the parties have commonly reached for evidential weapons to bolster their cases. They've tended to fall into three categories. Surveys, in which the signs put before a representative sample of the public and their responses are recorded.
I assume you would accept that there's a distinction to be made between surveys conducted for the purposes of litigation and surveys that are being done for ordinary commercial purposes, in the same way that we distinguish between experiments done for the purposes of litigation in patent cases and those that have been done for scientific purposes.
Yes, plainly, and I think what's been said in the authorities has only been talking about surveys carried out for the purpose of litigation itself.
Yeah.
However, the mischief underlying reliance on surveys, so far as probative value is concerned, can be the same or worse with surveys that haven't been created with the litigation in mind. It just depends. Obviously, they don't have the procedural mischief of inflating the costs in the sense that one's instructing people to carry out surveys and so forth. They do, of course, inflate the costs when one considers them a trial, but there's no process needed to obtain the court's sanction to admit this evidence in the first place. A subset of surveys is calling respondees as witnesses, which of course was the precise issue that the court was dealing with in Interflora 1. The second category is using disclosure or publicly available materials like social media, trawling through communications, posts online to try and find instances where confusion may have occurred and relying on the documents. And then there are the cases of actual witnesses said to have been confused or drawn a link or whatever you're trying to prove in real life. And in one sense or another, subject to the point about the type of survey, all these types of evidence are present in the case, save calling the respondees to the survey to give live evidence. And clearly the courts have recognised in recent years the procedural disadvantage of allowing survey material in and calling multiple respondees as witnesses, and indeed also calling multiple witnesses from the public at all to give evidence, and have often made procedural directions cutting down on that evidence in order to reduce the amount of time and cost spent at trial. But what they've also done is to examine the legal benefit of that kind of evidence, the ultimate question the court has to resolve. We submit it's important to take a hard-headed view of the extent to which evidence of the kind that the judge looked at in this case was capable of assisting, let alone leading to the result, which we say essentially is what the judge found, of a finding of infringement. And what I thought I'd do is just run through some of the cases that are summarised in an encyclopedic account of recent authorities on surveys in particular in the first Interflora decision in the Court of Appeal by my Lord Justice Lewison. And although the case considered was there to consider the utility of respondees, that's the right term, to a survey giving evidence on the question of confusion as a result of the advertising that was going on. It provides a useful resource, we submit, for considering the utility of other categories of public reaction evidence as well. So, if I may, ask your lordships to take tab 18 of Authorities Bundle 1. We would submit there is quite a lot of useful material here. And I'm just going to take you to some of the discussion of the law and the authority, starting at paragraph 36. And this, of course, addresses the specific issue that was before the court in that case, which was whether the advertisement of Marks and Spencers would enable a reasonably well-informed and reasonably observant internet user to grasp without undue difficulty that Interflora and Marks and Spencers were different. So this was an AdWords case where the consumer was tapping in Interflora and Marks and Spencers was popping up on the screen. As the ECJ has emphasised, not a question of counting heads, it's a qualitative assessment. The fact that some internet users might have had difficulty in grasping that they were independent is not sufficient for a finding of infringement. And that's the direct quote from the Court of Justice. If by analogy with Neutrogena and Choco Suisse, the court should conclude that most internet users would have grasped this, that some would not, I cannot see the court would be any closer to answering the legal question. So that's an interesting reference there to Neutrogena. Then we have a quote from Specsavers, which is the proposition that I've already looked at. And then account of bark flower remedies, where the question was, or is it batch flower remedies? I never remember. The question is whether the consumers considered it to be a trademark or effectively a descriptive or generic term. And from 13.8 over the page, there's a quote from Lord Justice Morritt, where he says, the evidence on the question of the average consumer, referring to Lloyd's shoe fabric, not limited to those who are consumers or end users, may extend to others concerned in the trade. Don't think the court's assisted by repetitious evidence from individuals put forward by the parties as archetypal average consumers, as no individual is such a consumer, and the issue can't be resolved by counting heads. And then there's a reference to the procedural practice I alluded to of actually saying, well, we're only going to hear from 5 on each side, which was something that was done at least in those days. Paragraph 39, we then have Lord Justice Morritt again, a reference to, in italics, the actions and beliefs of the persons who prompted the comments of the judge overheard in paragraph 36 shouldn't be attributed to the average consumer. First category of action appears to have been prompted by carelessness and ignorance, not to be attributed to the average consumer. The second rejected as evidence sufficient to undermine his clear findings, and therefore the expression would have been used and understood in a generic sense. So I can't see how a different understanding can be attributed to the average consumer. If the average consumer is regarded as reasonably informed, observant and circumspect, he must know the sense in which the word batch was used and understood in that sense was generic. In other words, the fact that you may find people who have a particular view doesn't mean you can attribute that to the average consumer. And then again, Lord Justice Chadwick at 41, task of the court to inform itself by evidence of the matters of which a reasonably well-informed and observant circumspect consumer would know, then treating itself as competent to evaluate the effect those matters would have on the mind of such a person with that knowledge, ask the question. And then in 42, he considered the evidence that might be helpful was evidence of what consumers knew, not whether they would have identified the words as a badge of trade origin. So this is the distinction I think Lord Justice Arnold was making a little earlier. Evidence of shopping habits might well be of value, especially in the case where the judge is likely to be unfamiliar with the relevant goods or services. But absent special circumstances, it doesn't generally help the court to call members of the public simply to say they would or wouldn't be confused. And my Lord Justice Lewison prefers the approach, insofar as there's a difference, I'm not sure there is, but the approach of Lord Justice Chadwick, which is very much the approach that I'm urging on your lordships in this case. Then we have Pot Noodle at 46. Now, that was an interim injunction case. I'm not sure of the general value of what's said there, because obviously it's at a very early stage and one's not had
It's also
disclosure
distinguished as being a
practices.
passing off case.
And
See at 46.
it is a passing off case. Whether such evidence would be admissible will depend on. So this is evidence from experts and members of the public. I'm not sure whether the goods were on the market or not. Whether these were people who'd actually seen them, it's not clear. Broadly, the test must be whether the experience of judgments from taken to possess as an ordinary shopper will enable him, just as well as any other, to assess the likelihood of confusion. If it will, the evidence will not be admissible. If for whatever reason it will not, then such evidence will be admissible. And then this was effectively saying it was an ordinary food product in 47. But I think
that's all
going on
talking
here,
about the expert evidence.
I think this was people who were saying they thought there was a likelihood of confusion. Yes.
Supposed
And then-
experts saying that they thought there was a likelihood. Of confusion.
Supposed experts. And then we have 48 is members of the public, and he doesn't consider them to be inadmissible, although I think they probably were artificially obtained, if I can put it that way. He says it's a D, unsatisfactory in a number of respects. He says, if, contrary to my view on the admissibility of evidence of those in experience with the trade, such evidence is admissible, there is a body of evidence. Over and above that is my own reaction as somebody possessing experience. I'm not sure how much any of that really helps. If we can move on to Esher at 49, again, there's that judgment passage in Lord Justice Arden. These are services identical of a kind familiar to members of the public. See no reason why the hearing officer shouldn't have decided the issue on his own in the absence of evidence.
But again, one has to remember that in issue, the issue was as to the expert evidence from supposed experts on likelihood of confusion.
Yes, I think that's right. And then in 50, which is summarising some of these cases, not only is the ultimate issue one for the judge rather than witnesses, also the judge can reach a conclusion in the absence of evidence from consumers. You all know that. And then from 60, we then get on to AdWords, I think. There is a review of surveys and witness collection exercises. Imperial Group and Philip Morris is quoted, or summarised rather, at paragraph 61. We may come back to that, but the relevant guidelines here requires a relevant cross-section of the public. That's the first one. Second one, a size sufficient to produce some relevant result viewed on a statistical basis. Give full disclosure is the third one. Fourth, no leading questions and mustn't direct the person into a field of speculation upon which that person would never have embarked had the question not been put. That we will see as an issue with surveys in this case. Exact answers, not some abbreviation. Totality must be disclosed, etc. And then the quote from Curley, very difficult to design a survey that will pass muster in court. And then in 63, there's a reference to the use of witnesses collected through surveys. And 64, the cynic might think the phrase witness collection programme is simply a euphemism by adducing evidence from a skewed selection of witnesses identified by means of a statistically invalid and unreliable survey. I think we would say we wouldn't necessarily have to be cynical to say that, but it is a very nice phrase for an extremely skewed exercise, unless, of course, you genuinely set out to provide a proper cross-section of everyone who gave evidence in the survey, which is not what tends to happen. So we go to, there's quite a bit of that and the reason why permission is required for surveys. I was going to skip on, if I might, to brief discussion at 73 of what Mr Justice Mann had done in Specsavers, where my Lord says Mr Justice Mann's approach is not cautious enough. I stress again what's an issue is the effect on a hypothetical legal construct. In the absence of special circumstances, how can calling 10, 20 or 30 witnesses selected from a statistically invalid survey be extrapolated into the effect on that legal construct of the adversarial sign in issue? And these points, whilst of course on the facts we're concerned with witnesses obtained by a survey, one might say the same about one or two witnesses coming from any particular manner of selection. Then we have a reference to Arnold's and the Trade Practices Commission at 74. In 75, they concluded survey evidence should be admitted only if it complied for reliability criteria which closely resemble Whitford guidelines. And then my Lord turned to the proposal in the present case, which was about the way in which witnesses were to be identified from the questionnaires. And although Interflora disclosed all the answers to the questionnaires, the remaining objections still hold good. The selected witnesses are not, or at least cannot be shown to be a fair sample of the class of reasonably well-informed, reasonably observant users. The consequence is no ground for any extrapolation on a statistical basis of the views of those witnesses. And if I can kick on with time in mind, to 86, it's an account of the Lego case, 86 to 87, which was another one where a survey was done and witnesses were called from the survey. And this was said to be allowable. And as my Lord says there, the reasoning was in two stages. Stage one's a survey that was representative of the population. Picture revealed stands proxy for the whole population. Needed to prove, because it was a passing off case, a substantial proportion of the population. So at stage two, the selection, it was sufficient to call witnesses who were representative of a substantial proportion of those surveyed. That was equivalent of a substantial proportion of the whole population for whom the survey stood proxy. So in a passing off case, it might be that you could carry out a survey, establish something on the survey, and then call witnesses who are representative
So
of...
what's the difference if it's a trademark case? Because as we've been over already,
Yes.
the parties are ad idem. There's no difference in our case.
No,
And we
absolutely.
also know that in a trademark infringement case, it's sufficient to establish that a substantial proportion of the relevant class of consumers would be confused.
If
So
that's
what's the difference?
when my Lord says the difference, the thing is that's not at all what happened in this case.
To be sure.
Yeah, but there
But
isn't
then
a difference.
The question then is, why are we undertaking this exercise? Because if there's no dispute as to the legal principles,
Well,
then it's all a question of the assessment of the particular evidence in the particular case.
well, what I'm trying to establish is what the principle is, and there are a number of aspects to that come out of these authorities.
Well,
The first
this is a case all about survey evidence conducted for the purposes of litigation. But that issue does not arise in our case, does it?
no, but important statements are made here about, for example, and one sees this if one skips on to 117 to 118, individual witnesses not standing proxy for the public as a whole, which
But
is...
in that case, you would never be allowed to call a witness in either a trademark infringement case or a passing off case.
Well, whether you're allowed to call it, one has to be extremely careful if they can't stand proxy for a substantial proportion of the public.
This goes back to the question we were discussing before. I can understand the logic of a submission that says evidence is useless and therefore should not be admitted.
Right.
The court must form its own view. But that's not your position, because you accept that evidence is admissible and may, depending on how it's evaluated, have some weight.
But in this case, no weight. One would have to go to extreme lengths to begin to show that a single witness, for example, obtained by contacting someone who you found in a disclosure document, could stand proxy for the public as a whole. The weight to be given to that evidence, once it's been admitted, is in our submission extremely low. And that's essentially consistent with everything that's said in these cases in the context of surveys. Must work
So,
equally well.
is it your submission that passing off cases where the courts have accepted evidence of actual confusion from small numbers of confused consumers were wrongly decided?
Not necessarily. If the judge sees enough logically to find it convincing, one would have to see how the evidence has been selected.
On the submission you've just made, an individual witness can never be proxy for the population as a whole. And that's true whether it's one witness, two witnesses, 5 witnesses, 10 witnesses. It's always true. So it would follow that logically, on your submission, that evidence should not have any weight at all, even if it's strictly admissible.
Yes, we would say the
So
weight to
all
be
the
given
cases in which evidence of actual confusion have been accepted, in passing off cases as well as trademark infringement cases, are wrongly decided.
well, not wrongly decided, because in the end, the judge, as is constantly said in these cases, has to come to their own view. And in many of those cases, as we'll see from further references here, as my Lord Justice Lewison points out about that evidence, it was confirmatory so far as the judge was concerned. So what tends to happen is the judge comes to a view and sees evidence.
Neutrogena is an example of the case where the judge said in terms that he thought confusion was unlikely until he'd heard the evidence of the confused witnesses.
Well, the judge had also heard all the rest of the evidence in the case and had seen how the marks were used in practice, had heard a lot about what happened in an individual store. I don't think it's possible to say he changed his mind just because a few witnesses were shown to be confused. He changed his mind from an initial reaction to the pleadings to his position, having heard all about the way in which these products were sold, what the reputation was, all the rest of it. I think it's easy to, if I may, to perhaps oversimplify the reasoning of Mr. Justice Jacob in that particular case. But what one sees from, for example, where have we got to? 117 to 118 is Mr. Justice Pumphrey. 118, 117, the evidence couldn't stand proxy for the average consumer. It was of no assistance. So these were genuine witnesses. But it's to be noted, the question imposed is whether the witnesses called could be said to have thought processes characteristic of the public. It is, I think, clear, considered the thought processes of one or two individuals are not probative of anything unless it was possible to extrapolate from them. I mean, it may be that a judge finds in a particular case that some insight is to be gained as to the level of reputation or the way in which products are sold from seeing a witness and hearing what happens in real life. But that's very different from saying, well, I'll draw a conclusion from this particular piece of evidence that contradicts what I would otherwise think. And there's then a reference to Julius Saman, and that's getting at the point where you see evidence where it's not tested under cross-examination. Very difficult to determine what the respondents are actually thinking. That's around J. Then there's a reference to United Biscuits and Neutrogena. As I've said, in United Biscuits, consumer evidence played no part in the trademark claim. Neutrogena, it was agreed they stood or fell together. And this was a case where I don't know how many witnesses gave evidence. That's a quote from Mrs Justice Kitchen. But the conclusion that my Lord Justice Lewison reaches about that is it's the case where, although the evidence was considered in the case of trademark infringement without objection, again it did little more than confirm the judge's independent conclusion. And then, if I can jump ahead, 131 is Specsavers. 132. Two further witnesses called to give evidence. Mr Justice Mann said their evidence couldn't stand proxy for the reasonably well-informed reason presented with circumspect consumer. And similarly, in 32 Red, Mr Justice Henderson, having heard evidence from 4 members of the public, said he reached that conclusion without needing to rely on any evidence of actual confusion. Though a certain amount of such evidence was tendered, I'll consider it in the next section. The test doesn't require evidence of actual confusion. If such evidence available, is likely to be of a confirmatory nature rather than an essential ingredient of the value judgment the court has to draw from all the circumstances. So, courts are downplaying, I'll put it that way, the value of the evidence of individuals for obvious reasons. Then there is my Lord Justice Arnold in Starbucks, where you rejected the utility of evidence from 4 customers, where I think they were probably expressing a view on an opinion as to the likelihood of confusion, so I'm not sure how relevant that is. And then at 135, there is the summary. Courts have allowed the calling of evidence of the kind interval which will have considered it, either in conjunction with or the absence of a statistically valuable so, but it's generally of little or no value. Sometimes it does no more than confirm the conclusion the judge would have reached without the evidence. Passing off cases, it sometimes has greater effect. It raises a different legal question. Unless the court can be confident the evidence of the selected witnesses can stand proxy for the persons or construct through whose perception the legal question is to be answered, it simply represents the evidence of those individuals. A case in which the witnesses are called in order to amplify the results of a statistically reliable survey, that evidence may be probative. But unless the court can extrapolate from their evidence, it is not probative. We would say that is a correct statement of the value of evidence generally. This kind.
Yeah, well, you can't stop there, can you? Because my Lord went on in paragraphs 136 and 137 to discuss matters that are perhaps rather closer to the present case.
Yes, and I wasn't going to stop there.
Good.
So 136 is a reference to the difficulty of evidence obtained by artificial stimuli, which is a particular problem, obviously, with the survey. And then in 137, not to say there can never be evidence called in the case of trademark infringement, the court may need to be informed of shopping habits, the market in which certain goods and services apply, the means by which they're marketed, and so on. In addition, I must make it clear different considerations may come into play where, 1, evidence is called consisting of the spontaneous reactions of the relevant public to the allegedly infringing sign or advertisement, and then some evidence consumers to amplify the results of a rival survey, not supplied to ordinary consumers, unlikely to be in the judge's experience, questions that require distinctiveness, where the cause of action is in passing off, which requires a different legal question to be answered. We would submit, what's going on here, the Lord is right, different considerations may come into play, but this is certainly not saying this evidence is always going to be useful. questions of the spontaneous reactions of members of the relevant public to the allegedly infringing sign or advertisement, as we will see, the problem of with that is if they don't come to give evidence, it's extraordinarily difficult to work out precisely what was going on and the circumstances in which the alleged reaction actually occurred. And so far as passing off is concerned, we agree it's a different legal question to be answered in the sense that we are concerned with a substantial number of ordinarily careful consumers, apart from rather than the average consumer. But as Lord Justice Arnold has said, it's materially very similar test. And the problem of individuals not standing proxy for the average consumer is also a problem of individual consumers not standing proxy for substantial numbers of consumers. And there's no logical reason why, frankly, it's any better in a case of passing off. I'm not saying the judge might not find the evidence of interest for a variety of reasons, but to draw conclusions as to which are effectively predicated on the witness being a proxy for a substantial number of people is, we would submit, not legitimate. Any more so than if the defendant turns up with people who aren't confused. I mean, that is the ultimate comparative question. Why do they not stand
Why so?
proxy
Because
as
the
well?
default is that people are assumed not to be confused. So proving the default gets you nowhere. What is of more interest is evidence that departs from the default.
Yeah. Well, except the judge, once he hears why people aren't confused, may be just as impressed as he is by having heard from one person that he was confused. Anyway, we'll. What's not discussed here is, as I say, the issue of spontaneous reactions where witnesses aren't called. And that's obviously even more problematic than if you call a witness, because you can't evaluate the circumstances in which what is said to have happened. Sometimes you can't really tell what happened at all. And one of the issues one begins to see in trademark cases is, since the advent of social media, a vast library of information which can get interrogated by processes of search, and statements being found which are, one party says are in its favour, the other party says are in its favour, or don't prove anything. One doesn't have the witness, and as we'll see in this case, one gets into an extremely difficult position trying to place any weight on it at all. And what we're going to say in the present case is that the kinds of evidence on which the judge placed heavy reliance were fundamentally never going to help her decide the question.
Can I ask you this question? Suppose Lidl had come to court with nothing from social media. Would you not have been making the submission that was made to me in Glaxo and Sandoz? Look, there's nothing on social media. This proves that members of the public are not confused.
I don't know. I wasn't there. In this case.
Because that was the submission that was made in Glaxo and Sandoz, and I accepted it.
Right. Well, I think there is a subtle distinction to be made. I mean, what the point I'm making is that one finds all sorts of ambiguous comments all over commentary you get on social media, which one is now used to seeing claimants seizing on and putting before the court to say, look, what's going on. The probative value of that might not have been very great, but I suspect the slightly tongue-in-cheek submission we were making there was that it is extraordinary that, given the amount of material that was put before the court in that case, that they didn't find a single response, even though we would have said, had they found a single response in Glaxo, that wasn't much use. I think the fact that in Glaxo we may have gone further and said it's surprising they haven't found anything is simply a reflection of that. If they found 110, given the millions of messages they must have searched through, it would have been no good either. Can I turn with that to the pillars of the evidence upon which the judge heavily relied, and we'll be able then to talk about these issues in actual concrete context as opposed to abstract terms. I'm going to start with the Vox Populi evidence, which I have to congratulate Lidl on the name that they came up with for this material, because of course the very name itself conveys the idea, completely wrongly of course, that the people have a single voice, or at least that the evidence can stand proxy for the people. What actually we had was a selection of messages which had been made by Lidl's lawyers, pulled from searches of vast reservoirs of messages. Three sources: Twitter, Lidl's database of communications with customers, and Tesco's database of communications with customers. Well, just to put Tesco's database into context, I think the evidence was there were 7 million communications from customers in the database over 18 months to 2 year period, I forget exactly how long. 7,000 of those referred to Lidl in various contexts, and of those some dozens, I forget exactly how many, were pulled out by Lidl and relied on. You see them all. We'd attach them to our skeleton, but they're so small the way the prints come out. It's better looked at, I think, in supplemental bundle C, tab 33, which I will come to in a moment.
Do you want us to get it out now?
It might be useful just to have it to one side if you've got space. Sorry, that's the wrong button.
This is page 802, is it?
So this is, thank you, yes, 802 is where it starts, and we've tried to colorise, because there are kind of different categories for different species of reaction, but it's the yellow ones which we think are the ones that are being said to evidence some kind of price matching reaction. I'm not going to go through them all. The judge didn't do so. What she did, if you have her judgment, at first of all paragraph 94, she pulls out 3 Twitter messages. In 112, she pulls out 2 Twitter messages and 6 messages to Tesco. And there's another message to Tesco in 113 and another one in 122. So the ones she cited, there are only 13 specific actual examples. And therefore, it's, save for those, it is hard to see how many of the examples in the exhibit she was actually impressed by. or whether in fact she really went through them all and worked out which ones might be illustrative of the type of reaction for which Lidl was contending. I mean, just to put some flesh on that submission, if one looks at some examples not cited by the judge, many of them don't seem to be remotely helpful to any case. For example, D9 on 810 in view of Sainsbury's and Tesco's price matched with campaigns, I thought a good slogan for Lidl would be price matched with our customers' pockets. Sorry, I couldn't find a more suitable email address. D11, there's just a reference to, and it's been pulled out in bold, Tesco and Morrison's matching many of your prices now. I mean, none of this obviously says anything about the yellow and blue campaign or what the person means by matching many of your prices, but it just sounds like the prices are roughly the same. D13, as Tesco's pretty well now price match Lidl. If your stock doesn't vastly improve, you're losing a customer. I mean, there are many, many like this where one simply doesn't know quite what the person means, but there's appears to be an entirely general reference. The interesting thing about the materials that were relied on is that there were a few instances in which people noticed that the club card pricing sounds used a yellow roundel on a blue background, that it was a feature of the Lidl trademark, and decided to point this out. And quite a lot of them seem to be angry about it. But none of those messages, as we point out in our skeleton, from people who actually referred to the yellow and blue, indicated they were believing as a result of that there was a price match. As I say, on the contrary, they tended to be annoyed or cynical. One can see that from the very first view. Little rip-off, copying little logo, I see. Thought this was a little advert. That's a reference, I think, to the aisle banners. Looks like she's zapping a little logo. That's a reference to the TV ad. And it was actually from that cohort that the two actual witnesses that we'll talk about were selected to give evidence to the court. So there's that cohort of people who mention the yellow and blue or say that the sign is similar to the little logo without any suggestion they're confused or believe there's a price match. And then there are instances where some general reference to Tesco matching little prices is made. I've shown you some of those already. And the judge, we submit, was over-impressed with this evidence. In fact, it's the only evidence which, in her view, supported her finding on the price matching allegation. And you can see that from judgment at paragraph 113, the end of 114, and paragraph 274.
274.
Where she's doing the passing on. So she comes back to this material time and time again, though she only quotes a very few of the actual statements in the passages that I've taken you to. Now, we submit that no such conclusions as the judge reaches in these paragraphs could properly be drawn from the evidence. It's simply not the case that the evidence that the judge was looking at, as she said, bore out the making of a connection about price matching on the basis of the yellow and blue, because there wasn't a single one.
You say two things, don't you?
Yes.
Following on from the submissions you've made earlier. The first is that in the same way that the judge, putting themselves in the position of the average consumer in a confusion case, will ask, is there a likelihood of confusion? So a judge in this kind of case should have asked, does the sign convey to me, as standing in the position of an average consumer, that there is price matching going on?
Yeah.
I don't think she ever asked herself that question. She
No.
asked herself in the abstract, is the sign similar to the mark? But I don't think she ever asked herself, do I get from the sign the allegation of price matching?
No.
And then you go on to say, and I think this is what you're trying to demonstrate now, that the evidence doesn't support that conclusion.
Yes.
But there's a missing first step if you're going to be consistent in the way you say the judge ought to have gone about her
Yes.
task.
Yes. So, yes, we say, having not gone through that exercise, she had already erred in principle on the right approach in this case. But in fact, this wasn't the case, even when one looks at it, where you could look for the answer in the evidence. And certainly, the evidence was never going to give you that answer. As we say, what the judge really did was, rather than come to the conclusion herself, clothing herself with the right attributes of the ordinary consumer passing off and the average consumer, whether there was this kind of message being conveyed, she sought to find the answer in the evidence. And that was always going to be a dangerous road. And actually, whilst there might be cases where one could see the evidence is tremendously impressive on its face, this was the absolute opposite. It was extraordinarily ambiguous on its face, and one couldn't actually draw any coherent conclusion, even about what was being said by the people who were sending the messages, let alone whether they represented a large cohort of the public. I mean, if you look at the longest set is at 112. And the price matching messages start on the third one down on page 592. Tesco price match with Lidl, meaning I can just stop at Tesco. Store provides all the food stuff like to purchase. Tesco price matches against Lidl. Price match Lidl on most things. I do like how you try and price match places like Lidl and Aldi. We're back to ripping off the logo. And then we've got Lidl price match, great discounts for club card members, good risk of range of products, etc. Without being able to interrogate the authors of these messages, it's not actually possible to really know what they had meant at all. Clearly, they thought something was going on which they were calling a price match. As I've said, does that mean they actually thought there was some guarantee of price matching, or they were just noting that the prices were the same. Had they made a mistake and intended to refer to another supermarket against whom Tesco were actually price matching? We'll come to the evidence about that. And even if they did think Tesco were price matching Lidl in a formal sense, was that caused by the sign complained of or some other reason? And because none of these messages tell you why they thought what they seem to have thought, whatever that was, you can't draw any conclusion linking it to the sign, which is the key to this case. I mean, just as a thought experiment, why would someone think that Tesco were price matching Lidl? There are plainly a number of viable possibilities. One might just have observed that when Lidl dropped a price, Tesco seemed to have done the same, just as you see competition between petrol stations and so on. You might just think Tesco prices had come down and were now the same as Lidl, and some of the examples are perfectly consistent with that. You might have been told by a friend or relative that Tesco were price matching someone else, Morrison's or Aldi, and misremembered. You might have just formed the view from articles in the press that all the big supermarkets were trying to match prices with the discounting shops. All these are possibilities, but without being able to interrogate the people who sent these posts, they are of no probative value in any particular direction.
Would that be a convenient moment?
I'm sorry, we're my learned friend reminded me and I'd clean forgotten it was 5 to.
2 o'clock.
Great.
All right.